CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS
Talk
Talks.
to me.
Real information.
Talk to me.
Real education.
Talk to me. Talk to me. They don't talk to me. They look like blue that morning. They don't talk to me. They back that morning. They don't talk to me. They back that morning. They don't talk to me. They back that morning. They don't talk to me. They back.
Welcome back to the CLS Talks, another one of our extended feedback sessions. We've had so many of them, so much good feedback, Des.
Oh, it's mighty. It's good fun as well, isn't it, really?
It is good fun. I enjoy these immensely, and we're getting good feedback to the feedback as well. So
The more the merrier. The more the merrier.
absolutely. So our first one for today. It's quite a long one, so bear with me. Hi, I was reading your article about Paddy and the TV licence and the Gary Doyle order. This was my experience. It may be long-winded, but shows the circus and the clowns we're dealing with. I was in my local district court in November 2014 for not having a TV licence. Apparently an agent for On Post had called to my address when I was on holidays, and our house sitter answered the door, who was asked, was he me? Answer, no. Do you have a TV? To which the house sitter answered, yes. So when I received the summons, I decided to summons Mr. Moore, the head of On Post licensing department, not expecting him to turn up, but he did, spending the whole day there, although I didn't call him. Just before lunch, the judge asked anyone who was in court for TV licence issues to talk to the On Post representative during the break. When it was my turn, I asked the agent had he spoke to me, to which he replied no. I then asked him what he had asked the person he spoke to. I told him it wasn't the correct question to be asking, as my sitter may own a TV, but I did not, and there was not one in my house. I was called by the judge, so I told him I did not have a TV but hoped to get one at Christmas or the New Year. I did not specify which year, to which the judge instructed me to get a licence by April 2015. I reiterated that I would when I'd got a TV and left the court. I eventually got a licence in May 2015 as we had got a TV. In late June I got a €500 fine from the district court stating I had not attended the court the day before and had been fined. I rang the local court offices and asked what was this all about, and was told that there had been a hearing in April which had been adjourned and put back till June, and as I had not appeared I had been fined in my absence. I explained that I had not received any notification for either date from the court or the DPP. I was told a load of crap, so went into the court office and filed an appeal. I appeared in December in the circuit court and waited to be called. I explained I did not have a TV at the time and had no notification of the previous hearings and was appealing the judgment. The judge then listened to the DPP and told me he was reducing the severity of the fine to €100, expecting me to accept. I told him I would not accept any fine as I did not have a TV for the period in question and asked for a Gary Doyle order. He told me he was only dealing with the fine and ignored me while he and the prosecutor talked. I was then told to approach and talk to the DPP, which I did. After 3 minutes of arguing, the judge asked if the DPP could continue, to which he replied no. The judge adjourned the case. In February 2016, I appeared again in the circuit court and explained that I had intended to continue with my appeal against the judgment, to which the DPP said he wanted the case to stand. During a break, I was ushered into a room by the prosecutor. He asked me what was the story, so I told him my side, as I did not believe he had any evidence to prove otherwise. He made a big issue of what the agent had filed and started to make a call to the agent, so I left. I stood outside within earshot, so I know he contacted the agent. When he came out, he told me he was waiting for the agent to get back to him. When I was called again, the prosecutor stood and told the judge my story, and that if it was okay with the judge, he was prepared to accept my appeal if I stated under oath that I did not have a TV in 2014. That was that. Appeal upheld. A week later, a Garda called to my house to serve the warrant for not having a TV licence because the court had not withdrawn the warrant. Laugh out loud. Regards, N.
Okay.
It's a biggie.
It's a long one, but it's actually quite a simple thing. Now, first of all, the man called for Mr. Moore to be represented of the TV licence inspector, and that Mr. Moore did turn up. I'm just wondering why he didn't cross-examine Mr. Moore, because he called for him to be there to be cross-examined, first of all. Right, that's first. Now, the other thing as well, why, I mean, we're critically looking at this, right? So the essence of a court case is the accuser has to prove their case. Okay?
Yeah.
Now, again, if you give evidence, be it right or wrong, be it correct or incorrect, The judge, you're given validity and jurisdiction to the court, the judge, to make a decision for the judge to decide whether or not you are right or wrong. Again, it's like two children playing. The parent will decide.
Yeah.
So by stating that he did not have a licence, or he did not have a TV, beg your pardon, he was actually given jurisdiction over to the court. The same thing should have been there. Well, can the TV licence inspector prove I had a TV? The burden of proof was not put on the accuser. So therefore, it gave jurisdiction for the court because he said, I did not have a TV. The judge was deciding whether or not the man was lying, and decided the man was lying, essentially.
Yeah.
And whatever you say in court is already, it's testament. You're giving testament, and it's the same as signing an affidavit. So that's why I remove myself from making such statements. And the clear thing is here, you need to shift the burden of proof back on to the accuser, which was not done. It's that simple. Now, they have nowhere to go because they cannot prove this man had or had not got a TV.
Yeah.
They couldn't prove that. It's not possible. Certainly, the babysitter or whoever was in the house said she had a TV. That's fine. Well, why weren't they prosecuting her?
Yeah.
So that's the other burden of proof. Say, well, the woman that gave evidence against herself, you don't seem to have in this court. You've got the wrong accused in the court. Isn't it true that the wrong accused is here in the court? If that woman said she had a TV, what was her name? Who was she? What was she doing there? Did she live there? All these burdens of proof should have been shifted back to the prosecutor, which they weren't. Okay. Now, the other thing it lends itself to as well is, why was the DPP involved? Right. The DPP were involved because it's a criminal case.
Yeah.
Okay. And therefore, the man should have stuck to his guns at the beginning and said, right, well, the burden of proof is with the prosecutor. Therefore, I'm seeking a Gary Doyle order. You need to prove your case to this court. Okay. When you provide full disclosure of the evidence you're relying upon, then we will cross-examine whatever witness that you have that pertains to have witnessed to these events, as in that can prove that I have a TV. That we'll cross-examine them and take them to town. Okay.
Yeah.
So there was a whole remit of mistakes made here, but it's good because people will learn. The best way to learn is to make a mistake.
Yeah,
you don't learn by getting everything right. It's that simple. So there was lots of mistake, but again, the key word here is the burden of proof. The burden of proof should have been shifted back to the prosecutor, to the TV licence inspector, to whomever was given evidence or acting as a witness. They didn't do that. The man that was being accused did not do that, clearly from what has been said here, because he said, I did not have a TV licence. You're given jurisdiction to the court to make the decision as to whether or not you were right or wrong. Okay? That's as best I can address it at the moment.
Yeah, I wonder what happened afterwards when the Garda called to the house to serve the warrant.
Well, equally, whilst they were at it, why didn't the man say, well, I want the warrant removed? You know, he had the opportunity when the DPP decided not to pursue it. Why didn't he say, well, notwithstanding that, you know, the warrant should be negated now or removed?
Yeah.
So the fact that the Garda followed up on this, see, it was a process, a protocol for them. That's all it was.
Yeah.
So again, it'd be interesting to see what happened after that. You know?
Yeah, I think so. So we'll go on to the next one. It's another long one. Hi, I'm always interested in your articles. The latest made me wonder about your Gary Doyle order technique for full disclosure discovery. Some years back, I was suing a firm of solicitors for the negligent handling of a fire damages claim. I use the word negligent in a loose sense, if you understand my meaning. The case was being handled by a third-party solicitor funded by the Legal Aid Scheme in England. The defendants were represented by a firm of solicitors funded and appointed by the Law Society. A nice demonstration of conflict of interest. The solicitor representing myself must have been warned off because he dropped my case suddenly. I carried on as a self-litigant, or a lay litigant, and discovered that several documents and letters were missing from the bundle. When the defence refused to send the documents I requested, I made an application to court for full disclosure. The judge granted my request, and we duly travelled to the offices of said solicitors, where we were shown into a small room to look over the documents. We asked where we could photocopy the documents we selected. We were told to put yellow stickers on the documents of which we required copies, and they would copy them for us. After 3 hours of trawling through the papers, we had marked 33 documents and made brief notes of each document, date, from and to whom, and brief summary of contents. At the end of the day, they said they would forward the copies to us. Time passed and several requests finally brought us 7 of the 33 documents. Further requests brought forth a further 4 documents. I returned to court with an application that the court order be complied with and that unless this was done, then summary judgment be made in my favour. The judge, while expressing some concern that 22 of the 33 documents had not been sent to us, when told by the defendants that they had no other documents that we listed, sided with them, saying that as they were solicitors he had to believe them rather than us. Thus, I expect, would any judge do the same even with a Gary Doyle order. However, the judge, on further prompting from myself that they were concealing documents, asked me what I wanted him to do. I said that if he was not prepared to act on the list we had prepared, then he must issue an order that the defence swear an affidavit to the effect that all documents had been disclosed. It was interesting to note that the affidavit was not sworn by the defendant's solicitors, but by a partner in the firm we were suing. There was a document in the bundle of which there were 4 copies. This was a bill of costs to the Law Society in the original case, a copy of which I slipped into my briefcase and was one of the documents we marked and whose existence was denied by the defence. The bill of costs included the sum of £875 for an expert witness report on the fire that caused the original damage. The solicitor had also claimed the same sum of money from account, as well as billing my insurance company for the same. I went back to court with an application to amend my pleadings as a result of what I had discovered from the missing documents. They were unaware I had removed a copy of the bill of costs from their bundle. The judge granted me permission and asked me to set out my amendments in consecutive paragraphs to the original, but to let him see the amendments before I included them with the main pleadings. At the next hearing, the judge read through my amendments and decided on a couple of changes he suggested. One was to delete a complete paragraph because he said it was adequately covered in the original, but I must not delete from the amendments, just put a red diagonal cross through it. The other thing that upset him was the word, quote, fraud in the heading of one of my paragraphs. He said that judges did not like the word fraud, yet he did not remove it from the body text. Next, the defence applied to amend their defence. This time they dug an even bigger hole for themselves by attaching altered documents and accounts which were different to those exchanged originally. My application in response was for summary judgment on the grounds of dishonesty in pleadings by way of forged documents defined as fraudulent under the Theft Act of 1968 and the Fraud Act of 2004. They brought in another judge from 60 miles away. She said that I was making very serious accusations against a well-respected firm of solicitors. Their barrister was already in the chamber when I entered. Both he and the judge were holding an identical photocopy of a newspaper article on a case of slander and libel with which I was threatened. Truth and evidence is proof against slander and libel, I told the judge. She dismissed my application. With best wishes, P.
Okay, well, it's a story. I think to get a better handle on it, you need more detail and to reread it over and over. There was one key point that I think was when they went in to review or view the documents, I should say, in the solicitor's office, they had a chance right there and then to actually, rather than seek permission to do something, sometimes it's better to beg forgiveness, as they say. So in those circumstances where you get an opportunity to perhaps view documents, I'd be inclined to take in something whereby you would be able to take a copy yourself. A phone, for example.
Yeah.
Good phone, good camera. And okay, back then perhaps they didn't have the quality of cameras that you have now. Quality of phone you have now, but certainly cameras, a small camera, and what are they going to say to you? Stop photographing the evidence.
When you're there to get a copy anyway.
Exactly. And where they've allowed you to, at some stage where they would photocopy the documents, all you're doing is taking a pre-copy. So there'd be an issue there if they stopped you or prevented you from taking photographs. But I wouldn't make it obvious. You just go through the documents, photograph the documents as if it's normal.
Yeah.
And that's it. So when you get a chance to view documents, this is the only thing I'd pick up on, is photograph them. And that's it. And then there's no question as to what happened and what was missing. It's quite a complex case, and as the man rightly pointed out, the judges don't like to see fraud or the words perjury in documents. But again, if you're going to put those words in, and it seems like the man had done his homework, fraud and perjury is fraud and perjury, and get the definitions of it.
Why don't they like the words? Because it's been thrown back at them, or
Yeah, you see, it infers that, you see, if there's fraud on the court, it brings the court itself into disrepute, and it's something that the judges should be picking up on.
yeah,
It's not something that they can let slide by. It's something the judges should be wary of, that if there's potential fraud in the court, you bring the court into disrepute. So it's the judge's job to preclude and prevent an abusive process by allowing fraud and perjury before the court. And if the judge doesn't do that, the judge is acting in contempt of the court itself.
right. So there can be a big headache there potentially for the judge.
It's not so much a big headache for the solicitor or the barrister or whatever, it's for the judge
Yeah.
itself, because then it opens itself up to a review of the judgment and to a possible appeal. And judges don't like those things. They like the straightforward black and white, this is done and dusted. So I would make an issue now, and again, something that they point out very clearly. Now I don't see the question in this, because they've kind of ended it without a real conclusion.
Yeah, there isn't really a question. Yeah,
So the only thing I'd point out here, they were talking about truth and evidence is proof against slander and libel, or defamation as they call it. So that is true. You know, if you're stating the truth, and there's many people we've been dealing with, and accusations of defamation, notwithstanding myself, accusations of defamation have been thrown at me, and most of the letters and notices I would write would constitute questions. So you cannot be accused of libel and defamation if you put it in a question. So that's what I'd be very, very careful. And it's very easy to get labelled that what you're doing is defamation. But if you're asking a legitimate question and you're stating something that you know to be true, it cannot be slanderous or libel.
exactly. And a question is not the same as a statement or an allegation.
Yeah.
Or anything like it. So it is a good kind of buffer to put between yourself and any of those kind of accusations.
Absolutely, it's very good. But it's not a bad thing necessarily. If you've structured your case, perhaps structured your letters and your notices and whatever else paperwork you're doing in the right way, and you're as time goes on, you get a bit more confident, certainly, and perhaps even on the face of it a bit more aggressive in the way you put things. You can put questions in there that really light fuses for them. They don't want to be asked. And you can be very direct with it. And even a judge will back away to a certain extent if you put in questions like, isn't it true that you are guilty of an abusive process?
Yeah.
Or isn't it true that you were guilty of, or you have shown a proclivity to rush this matter to judgment? Now, obviously, judges don't like it. But I think you're better off putting that to a judge in the context of, well, get them to blow a fuse. Get them to blow a fuse.
Yeah.
And then get them to say, and then afterwards when they blow their fuse, say, well, answer the question. I still want you to answer the question. Have you finished now with your blowing of your fuse, or have you finished talking? No, I still want you to answer the question. That's when you kind of have them cornered. When you see somebody getting angry, they're getting angry for some reason. I mean, you don't often get angry when I'm talking to you because you have no reason to get angry. And similarly with me, I don't have a reason to get angry with you.
Yeah.
Now, if you pushed my buttons, I probably would have, but you'd be onto something.
Exactly, yeah.
So when somebody gets angry, it's because you either know how to push the buttons already, or you've inadvertently pushed a button that they didn't want pushed.
Yeah, and I think you're dead right. Like, you shouldn't necessarily shy away from touching that nerve.
Absolutely.
You should get it out there.
Yeah, and that's the one thing, we've talked about this before in a wider context. It's something that certain people or parties, persons, whatever you want to call them, don't like. They don't want the exposure. If you can say to a judge in open court, well, isn't it true that you did actually facilitate perjury here? And put the question to the judge, and the judge will blow a fuse.
I've seen it happen.
And say, well, I still want you to answer the question, isn't it true you did that? Or is it true you did that?
Yeah.
So there isn't any harm. But again, you'll grow in confidence as time goes on with asking these type of questions. But the starting block for that is to ask those questions in writing.
Yeah.
Yeah, and put down a question that you would not like to be asked yourself. Like, we've often put down questions in relation to where we know a witness has lied in the stand. And
Right.
we've said, like, isn't it true that you have brought this court into disrepute by lying? Now, we'd run into the question by using the term perjury.
Yeah.
And then we'd replace the term perjury with the word lie. And whatever about the word lie, whatever about the word perjury or fraud not being liked in the court, they really hate the term lie. If you're calling somebody a liar, But as my parents brought me up, you're either lying or you're telling the truth.
Yeah.
And when you're lying and you're caught out, you won't like it. You'll blow a fuse.
Yeah, nobody likes that.
No. So it is that simple. But that, I mean, all this does really, this letter isn't really a question. It just gives us a case study of what happened to this man, A, B, C, D, and what he came across, which is interesting in itself.
Well, we've another few to get through, so we will do that. Hello, I've been following the CLS talks, and my email today refers specifically to talks 8 and 9, where you discuss a letter which was issued on behalf of Mary to Carlow County Council regarding a fixed charge notice. It's my understanding from the dates of the uploads that this correspondence issued to Carlow County Council in October 2015. Has there been any further correspondence from Carlow County Council on foot of Mary's letter to them? And will you be doing another talk on this topic? I too have received a fixed charge notice, and I'm currently working my way through the legislation referred to in the talks and on the fixed charge notice itself. I believe I understand the points raised in the letter referred to in talks 8 and 9. But I'd like your input or thoughts on the wording of the fixed charge notice, which states, quote, "The alleged offence is parking a vehicle in a disc parking car park without displaying a valid disc," unquote. However, the requirement of the notice is that by paying the fine, I am accepting that I was, quote, "driving or otherwise using the vehicle referred to in this notice at the time of the commission of the alleged offence," unquote. Or if I was not, then I have to supply the name and address of the person who was, again, quote, "driving or otherwise using the vehicle referred to in this notice at the time of the commission of the alleged offence," unquote. If the alleged offence is parking the car in a certain place at a certain time, then how could I have been driving the car or otherwise using the car at that time? Thank you, NM Sligo.
Okay. Just to round this off for people, Mary, after we did the last, I think it was talk 8 or 9, didn't hear anything back from the council.
Yeah.
So that ended there, so to speak. Now, the wording that this woman or man, I'm not sure if it's woman or NM, refers to here, the alleged offence of is parking a vehicle in a disc parking car park without displaying a valid disc. To me, there the key word is alleged offence. Okay, so like when you go into court and they're alleging you don't have a licence, they're alleging you broke the speeding limit, they're alleging you parked in a place you shouldn't have been parking in, then the burden of proof is back to them. Mm-hmm. So the simple thing here for me is, right, well, what proof have you got that, first of all, that I was responsible for that car at the time, I was driving it, I did park it. So what proof have you got? And you go on from there. You cannot move on you can't go on to anything else until you see what evidence they have that they're prepared to go into court, and a witness statement, if there is a witness statement. Yeah?
Yeah.
So that's where that ends until such time as the accuser comes forward and proves that it was your vehicle, car, and that you were illegally parked. And again, you should be checking the laws and the bylaws of this town that you're in as well, because sometimes those laws do not exist to preclude you from going into those places, which we found on occasion as well. So it starts and ends with the burden of proof. And then ultimately it might lead on to you cross-examining the car parking attendant or the traffic warden, whoever it might be, and then checking what they know about the law.
Yeah.
And whether or not they actually have first-hand knowledge of you doing or committing an offence. And equally as well, I'd start getting into, at some stage, whether or not this is a criminal offence. What crime was committed? Was there an intent to commit a crime? Was somebody damaged? Those have to be present at the same time for a crime to be committed. And you're in criminal court, albeit a lower minor court, it's a criminal allegation.
Yeah.
Because if you look at the resultant of what might happen to you, it could be a heavy fine, could possibly be an imprisoned term, and possibly another issue as well. So it will affect your life in a negative way if you get convicted of this offence.
Yeah.
So that's all I'd have to say.
So it boils down really to finding where the burden of proof lies, which obviously is going to be
With
to
the
them,
accuser,
throwing
yeah.
it back to them, and then staying steadfast on that point until such a time as they either can't prove it or do prove it.
Yeah.
And that's it.
Or looking at what they're relying upon as their evidence. And again, what we have found recently is that the courts do not want to talk about what we called before mens rea and actus reus.
Yeah.
They don't want to talk about this thing of a crime being committed, as in an intent to commit a crime and an actual act of a crime, and or the fact that they don't actually have a particular victim. There is no victim. It's what they sometimes coin as being a victimless crime. There's no such thing.
Well, it can't exist in law.
Exactly. There isn't a victimless crime. It's either a crime or it's not a crime. And parking a car, per se, in a place, how can that be a crime? Who have you hurt? Who have you damaged? Who have you stolen from? Well, obviously they will argue you've stolen from the council because you haven't paid the charge or the fee. But when it brings it back down to it, what particular victim do they have?
Yeah.
Who's the victim?
Produce the victim.
Correct. Because what they have is a witness who is not competent. Now, I don't mean that in the context of necessarily they don't know the law, which in most cases they don't know the law anyway.
But let's assume they do.
Yeah. Let's assume they do. Well, no, let's assume they don't, because we've never come across.
Well, that is true.
witness.
Never in all the history of all the cases
So
have
far.
we ever seen one. Yeah.
So far. But then again, you have to ask yourself, if these alleged witnesses, i.e. car parking attendants and traffic wardens, knew the law, would they be doing that job?
Well, that's the thing. And if they knew the law, would they have you in the position you're in right now anyway? They wouldn't.
No, they wouldn't. They wouldn't bother. So there's 3 or 4 things. If you start bringing it deep into the criminal law, the court have nowhere to go. You know, you start saying, well, actually, under the DPP guidelines, as per your laws, they have to have a particular victim. The witness has to be competent. There has to be a demonstrable, provable crime with the proof of intent to commit that crime present at the same time. That's an impossible thing to prove, and it proves difficult for a good, say, defendant, even in a court case, for the accuser to prove that. In a serious crime, it's very difficult to prove. Now, very often what you'll find is the solicitor or the barrister involved will cut a deal, a plea bargain, as they say, or cut a deal whereby if you plead guilty to this, we'll only do this to you. But all criminal cases, on the face of it, should be demonstrably very, very, very difficult to prove. They're not, because most people end up giving evidence against themselves.
Yeah, and it's very interesting just to note some of the transcripts of high-profile criminal cases that have taken place in Ireland over the last while. Some very, very high-profile ones. Now, I'm not going to get into whether I think somebody did or didn't do what they were accused of, but there are so many cases. I can think of one very high-profile one over the last couple of years in particular, where the head of the investigation, the prosecuting detective, shall we say, actually admitted in open court that there was no proof or evidence, yet the person went down for what they were accused of. And I mean, that lies with the individual concerned trusting the solicitor or the legal professional and them not actually doing their job correctly. I mean, forget about what they're accused of doing for a second and look at the pure law. It's not that easy, as you said, Des, to actually prove a case. It's not that easy. Yet, if you were to look on the surface, you would assume it's very difficult to defend a case.
Yeah.
Because so many cases are successfully prosecuted.
They're successfully prosecuted in a nutshell, because if, as you say, you read the transcript of what was said in the court or what preceded that in terms of giving evidence, the witness gives evidence against themselves.
Yeah.
There's a very interesting clip out there on YouTube. I think we've got a version of it as well linked on there somewhere. It says, I think the title is "Don't Talk to Gardaí." Yeah, do not talk to the Gardaí.
Yeah.
So if you type that into YouTube, or do not talk to the police, and it's a professional university lecturer, and he brings in an inspector, a cop, in to back up what he's saying. And he's saying all the time, this is a university professor who's teaching law, and he's got the students there, and he's saying to the students, when you eventually do become solicitors or lawyers in the States, as they call them, the first thing you have to teach your clients to do is not to speak to the police. That's the first thing. And even to say no comment is speaking to the police. The only thing you should be saying is, I want my solicitor, I want my lawyer, I do not want to be interviewed, I do not want to say anything, and that's it. You stand there on, as they call it, the Fifth Amendment, but equally here, you say, I have nothing to say, thank you very much.
Yeah.
If you want to prove a case against me, go ahead and do it, but I'm not giving you any information. So in all cases, no matter what it is, you should not be talking to the police, to the guards, whatever you want to call them. The more you talk, the more they'll have on you.
Yeah.
That's it.
Okay, so a couple more to go. Hi guys, I recently received a provisional threat warning about not having a TV licence.
TV licence is coming in here big time.
Oh yeah. It was a standard postcard layout on which they placed both my forename and something resembling my wife's forename on the card, followed by the surname, and placed it in the address section. Now, I know this is most definitely a technical fault regarding any future legalities. I found it quite amusing that the printed statement said that our TV licence inspector was unable to gain attention at this address today. A truly amazing opening line. Does this infer that I'm expected to wait at all times by my 8-foot high front gates for some invertebrate to quiz me about my possessions and that I must attend to him? The gates are 8 foot high for a reason. It goes on to read that according to their records, my address is not covered by a current TV licence. So what? I did not request that my details be put on their database. The fact is I don't have a TV. I don't want a TV. Firstly, since I have no intention of legally acknowledging an incorrect statement, I will not reply to this card. However, these reptiles may attempt to serve a summons at some stage, and I would like to be ready for them. I love a good fight, and I've dealt with several civil cases already quite successfully. It would be my intention to counterattack with a charge of malicious litigation, since they will try to bring a charge against me without any evidence, and it could possibly be an act of perjury for the court clerk to allow hearsay as the backbone of a grounding affidavit. I have heard of many cases thrown out, dismissed, and incredibly, one with no fine, just a probation order made against a friend of mine who didn't own the TV. His girlfriend did. It wasn't even his address. I'm not interested in simply defending myself. I would prefer to go straight for the throat should this proceed. Have you had any experience with this? Any advice would be appreciated, and of course I would love to encourage others to do the same. Best regards, Jay. We'll reiterate that we don't give advice, but we will discuss.
Yep. Okay, well, it's stuff we have discussed before. Now, certainly there would be a case here for malicious litigation and for bringing in a case against them, certainly.
Yeah.
And then that would, if you did bring in a case against them and lodged it before the hearing date or on about before the hearing date, then you could argue with the court that this case was not to be heard until such time as this case that we have lodged against you had to be heard. So that could take a long time, which would drag it out. Now, equally, as the phrase he has here is he'd like to go for the throat. Now, there's different ways of skinning a cat. And you can go for the throat even though they're attacking you. Okay, if you learn to read what they're doing, learn to throw it back at them. Because if you got a good, level of law in your head and prepared a good cross-examination, you could tear strips off the TV licence inspector themselves as to, first-hand knowledge, as to no evidence, no witness, no crime, blah, blah, blah. So my inclination would be to hold back and let them go forward, then seek the evidence of disclosure of evidence, and then get the man or woman, that's the inspector, into the stand.
Yeah.
And then put them on the hook, get them hooked in. Obviously, the only thing you're going to have to manage then is the judge. And in either case, even if you were taking a case, you're going to have to case manage the judge. So in this case, I'd much prefer that they were coming after me. I put up the barriers and then stick an old spear out every now and then.
It's like the case we discussed, one of the prior episodes. I think it's called A Case for the Defence. It's a two-part thing we discussed. And while that's not dealing specifically with TV licence, the approach that you're describing is the approach that the man used in that case. Yeah. And I think it'd be a good one to have a listen back to maybe for this individual. Because as you say, it's like the warrior code or martial arts. You can use the power of your attacker against them ultimately to defeat them. Yeah.
And you see, when you're cross-examining, now again, it takes a bit of work, a bit of energy, a bit of knowledge and a bit of practice to get cross-examination fine-tuned down to something that is going to actually really hurt them. But you'll find out pretty soon in putting together a decent cross-examination, there's no end of questions you can ask. I mean, you could have the witness that they are relying upon in that stand for days on end, and still go back again and again and again. I mean, the typical example would be if people looked at, obviously, the case of the defence, which we've covered before, and the Gary Doyle order. The intention there was to have the guard in the stand forever.
Yeah.
Okay? Have him there. And after 3 hours, 4 hours, 5 hours of being in the stand, you could see demonstrably that his physical demeanour was down.
Yeah.
He couldn't deal with the pressure of being asked. I mean, just think about it in terms of the context of, you now have somebody that perceivably was in a position of power telling somebody else what to do, i.e. the guard was telling this man or woman what to do. And now they're in the position whereby they're sitting there having to answer the questions that were being thrown at him. And he knew, and the judge knew at the time, this is going to not go very well.
Oh, it's a most unenviable position.
Yeah. So I'd be more inclined, as suggested earlier, to sit back. If a summons does come, obviously they have to get service and blah, blah, the whole remit of stuff that has to happen there. Well, then I'd be keen then to wait for the date, get in there, get a Gary Doyle order, have the debate about that. But again, be keen to get in there to cross-examine their witness, because there's no end of holes you can punch in the witness. Now, you're not just punching holes in the witness, you're punching holes in the court and the state as well, because that's it's the state that's actually prosecuting you. If you got an order against you in relation to a TV licence, it's the DPP now that would follow up. It's a criminal case after all. So that's what I perceive as being the opportunity. It's the counter-attack.
Yeah.
Rather than a new attack, it's a counter. It's like the analogy of looking at football. Very often the best way to win a game is let them put pressure on you, and then when they're tired and weak and they've thrown everything at you, you counter.
Well, haven't Leicester City just won the Premiership, a perceived underdog, tipped for relegation? They've won the entire thing based on exactly that tactic.
Yeah, that's again, we alluded to this before. We might do a session on the art of war.
I think we should. A lot of that is coming up in this
definitely.
addressing this question. So we've one more to go, Des.
Have we?
We do. And it is as follows.
Okay.
Hi CLS. Just wondering if you're thinking of doing anything on the property tax. I know it's nothing to do with you, but was wondering, as I am now being threatened by revenue that they'll take it from my wages. They had started deducting from my wages 2 years ago, but then I lost my job, and thank goodness they didn't catch up with me while I was on benefit. Now that I'm employed again, they've given me 14 days to make declaration, or they'll instruct the employer, who is my husband, to deduct €200 plus €495 in equal instalments over the coming months. I have left messages on Facebook for Attack the Tax, but to no avail. I really don't want to pay this unfair tax. I was thinking of ringing Revenue and asking them what was a declaration and is it mandatory? I'm sure you're saying to yourself, yet another idiot who's trying to learn how to swim while she's drowning. If you can point me in the right direction as to what my next move should be, I'd really appreciate it. Anyway, thanks for all your incitement emails to date. Kind regards, B.
Okay. Perhaps this is the last word we should have on specifically this issue, or maybe not. Maybe there's another reason we could have some discussions later on. But for all intents and purposes, just to clarify this for everybody, the Common Law Society are not involved with the tax or the other issues there. Those were taken from us a long, long time ago. But again, just to give cognizance to what the woman says in recognition, I'd refer back to the case of Peter Anthony Keegan in Westport. Now, I think it was a year ago or 2 years ago, he actually won his case. And the case itself was based upon, and we spent hours and hours and hours with Peter Anthony Keegan teaching him about aspects of the law and so on and so forth. And I'm not taking away from him, but there was a lot of work put into that. And it boiled down to this, that he said to the court, basically, if you have the law that can force me to make a declaration, go and get it.
Yeah.
And the court prevaricated for 3-4 years and eventually said to the council, the county council that were brought in the summons against him, this is a criminal case, by the way, the court said, well, look at, bring the law in. If you can force this man to make a declaration or sign an affidavit or make a declaration against his will, bring it in. And the council then withdrew the case because they couldn't.
Yeah.
That's what it boils down to. Now, it's a more complex story here. Obviously, the woman is employed by her husband, I think it was.
That's what it says, yeah.
Now, so the issue then would be, the real issue is with the husband then and Revenue, because Revenue will be coming after the husband to get the employee, per se, to make a declaration. Now, you cannot force somebody to make a declaration against their will. So, in response to Revenue, if it was me that was employing my wife as an employee, I'd be writing back to Revenue as the employer and saying, well, actually, if you think you can order somebody to make a declaration against will, by all means do it. I can't do that. Now, if you think you can order me to do that, do it.
Yeah.
So, can you give me an order to order somebody else to do something against their will? If you can, do it.
Go
and I'll
for
be
it,
more than happy to consider going for it.
Yeah.
I'll consider it, certainly. I'll actually have to check the validity in law as to whether or not you can do that. But certainly, if you can make an order to order me to order somebody else to do something against their will, go for it.
And that's the crux of so many cases with regard to taxes.
Exactly. And they can't do it. Like, we have an incalculable amount of cases whereby we've said to courts, if you can make the order, make the order, and we'll consider agreeing to the order, as in, if you can order us to sign a declaration, make a declaration, agree a contract, agree an agreement, sign an agreement, sign a contract against our will under the European Convention on Human Rights or the Constitution or the International Convention of Rights, and there's political rights and civil rights and all the rest of it. Do it. Show us the law under which you can do it, and we'll certainly consider doing it.
Yeah.
Yeah. That's what it boils down to.
Pretty much.
Yeah.
And it brings us to the end of our feedback. Well, I mean, I'm sure we'll have plenty more feedback specials in the end. We didn't think it would be quite so much, but we just had a sheer volume. We wanted to get through everything.
Yeah.
And I've certainly enjoyed teasing them out with you, Des, over the last while.
Oh, my pleasure, Lionel.
So we will be back with the CLS talks, of course, with many more rip-roaring and exciting episodes. So don't forget to check the website as well, thecommonlawsociety.com. And we will speak anon.
Thanks very much, folks. Thanks for listening.
That morning,
The CLS talks.